Defences 1. Capacity and mistake. I'd like to talk to you now about some common defences. We've looked in previous tutorials at some defences. We have covered the partial defences to murder, for example, and we've looked at the defence of consent to offences against the person. In order to contest a case against them, a defendant, in a criminal trial, can either argue that the facts are not as the prosecution allege them to be, argue that the actus reus or mens rea is not made out, or present a substantive defence to the charge. We are now going to look at situations where the defendant does not have the capacity to commit the offence, such as infancy, insanity, automatism, intoxication. We will also look at the defence of mistake. In the second part of this tutorial, we will look at excusatory and justificatory defences. Infancy. The Children's and Young Persons Act 1933 provides that children under 10 are presumed to be dolly in capax, i.e. lacking the capacity to commit crimes. The rationale behind this is that children under 10 do not fully understand what is right and wrong, and the consequences of their actions. This issue relates to the age of criminal responsibility. This age of criminal responsibility varies from country to country, and England and Wales has one of the lowest ages of criminal responsibility in Europe. We used to have a rebuttable presumption of dolly in capax for children aged between 10 and 13, but that was abolished in 1998.